24 квітня продовжуємо.
We are beginning our work at the Media Center Ukraine. Your anchor is Svitlana Cheparenko. We are now presenting a memorandum for the law enforcement and judges on effective investigation and trial of cases involving conflict-related sexual violence. Today's panelists are online. We will have Svitlana Yakovleva, the judge of the Criminal Cassation Court at the Supreme Court. With us here in the room is Sergiy Nizhynskyi, PhD in law, senior and legal advisor to the Deputy Minister of Social and European Integration, advisor to the Ukrainian Parliament Commissioner for Human Rights, Snyzhana Kushis, National Coordinator, Angela Stryzhevska, the head of the Department of Criminal Policy at the Educational and Scientific Institute of Law, the Taras Shevchenko National University in Kyiv. Evgenia Lukavchenko will be talking to us online, and Vice Prime Minister Alexander Osipov here is the acting Deputy Director of the Department for Monitoring of Observance of Equal Rights and Freedoms, Rights of National Minorities, Political and Religious Beliefs of the Secretariat of the Ukrainian Parliament, Commissioner for Human Rights. Tamara Zakrevsky, the Deputy Head of the Department of Trainers at the National School of Judges of Ukraine. Welcome, everybody. I would like to begin our table talk with the video. Evil must be punished, as we have seen in this video. Very important words. This is a sensitive topic when the enemy is constantly committing crimes against our people and this country. Today's memorandum is one of the steps towards justice, justice at the national level and hopefully at the international level. Mr. Sergiy, could I turn to you? Will you brief us on what is the importance of this memorandum? Who are the people who have stepped up to the plate? Thank you for the opportunity to present this memo at the Ukrainian Media Center. Today is the official presentation of the document when it has seen the light of the day. During the implementation of many a project together with the UNFPA under the auspices of the Vice Prime Minister for Euro integration, we have conducted a number of actions on verification of the needs, not only of the victims, but only for the people who work with the victims, the judges, the commissioners and ombudspersons. What we have seen is that everybody is understanding the importance of the investigation of this particular kind of offense with no statute of limitation that is muted. But on the other hand, we see that the cognizance of the most important things to pay attention to and focus on in our reflections on decision-making, in writing thoughts, has become a key issue. Over the reflection of what had happened in Bucha, we have found out that 70% of the victims were male. When we talk about gender aspect of this crime, According to the General Prosecutor's Office, 274 proceedings have been transferred over to the court examination, and the majority of them, as I have been perplexed to have seen on the Ukrainian Truth newspaper site, to the fact that UN has declared that there are 76 victims of these war. Now, our General Prosecutor's Office talks about 274 cases. Different organizations, including the government of Ukraine, have published other statistics. This disparity makes me wonder, why is it so? The correlation of the numbers is there. On the other hand, we are aware that for such a process to be set up, process of investigating, it's important to envelop the European court cases and the cases going back to Bosnia and the Balkan conflict. Kosovo now claims that there were more than 20,000 victims of the war. This promotional work in Ukraine brings different results and numbers. I'm sure that the victims are much higher than 274. We know from the media, from the publications, the specialists and the psychologists. But what is the specifics of work with the victims? We understand that any social assault and violence can bring in a very deep trauma. There are specifics of how to work with the victims, how interrogation should be conducted. We have been trying to minimize the time when the victim is interrogated. We thought it's practical to have one interrogated, taking on board the Balkan expertise. The ombudsman of the Ukrainian parliament has initiated to single out a special kind of crime into a separate points for the register of damages, according to paragraph 11 of the postulates of the damage register, saying that the victims of sexual assault should go through different procedural actions and so forth. It was, and it is very important, a memorandum for us, because it provides an opportunity to make people think, to make judges think, to prompt the parties to the proceedings about the opportunities and the consequences leading from the European court cases, from Croatian, Rwanda cases, cases that are very often referred to by the academia. I'm sure that today's panelists, co-authors of this memo, people who have been closely reading every point, bringing in our discussions and initiatives, I'm sure that this will become a practical guide, a practical document to help, in the first place, to pass absolutely fair decisions and, of course, to protect the interests of the victims. Thank you, sir. I would like to ask you about the practical role of this memo. I would like Svitlana Yakovleva to join us. We are waiting for the judge to participate in our discussion and highlight the importance of this booklet for judges. Welcome. I was asking how this memorandum is going to help judges and investigators in investigating such cases. Why was it important to come up with such a memo? Welcome, everybody. And participating in the discussion, I would like to underline that this memo has quite an importance and will be useful for judges in practical dimension in the first place. As the result of the armed aggression against Ukraine, this country and the justice system included faces a number of challenges, including the investigation and examination of a new category of offenses, military crimes. As far as the sexual violence is concerned during the war, the number is not that high that is being investigated, but it's part of the military war crimes. The qualification of the perpetrators of this particular category, their importance is very difficult to overestimate, to investigate and to bring the perpetrators to justice. It is very important, I will repeat, such a category of investigation and examination and gathering of evidence has a number of specifics. The judges, as the law enforcement in general, that deal with investigating such facts, they should not only follow the national legislation, but international standards in this realm. This is why the memo on the qualification of the sexual violence in war-related conflicts is targeted towards judges in the first place, again, according to the Ukrainian legislation and internationally. Again, to repeat, this is the first time that we have confronted such a category of offenses. We are applying international mechanisms to provide a high-quality investigation of such cases. Another point to underline is that while developing this memorandum, we have taken on board international expertise, and a number of Ukrainian scholars have participated, including Shevchenko Kyiv University and the Office of the Prime Minister for European Integration, Ms. Stryzhevska, testifying to the fact of the urgency and high level of research. Judges have also participated in this work, but at the Cassation Court representative, we are now understanding the challenges that we are likely to face, including other categories of the war crimes and war-related sexual crimes. Such issues are associated with the facts when such cases are wrongly qualified, including sexual violence during hostilities. Ukrainian legislation includes an exhaustive list of norms relating to international documents, and more often than not, when we talk to our judges, we understand that not all judges realize how international norms can be applied to national legislation. That is why this memo will come in handy. Another point is that this memo accumulates the experience of the highest court, Supreme Court, because we are aware that the interface between courts and the victims is a guarantee for a successful investigation and bringing perpetrators to justice. The main thing here is that this cooperation is aiming not to harm the victims, but rather to receive information, for this information to serve as an evidence in bringing the perpetrators to justice. Another point is that judges of the Supreme Court are investigating and learning from the international experience, and one of the visits of our visit toward the International Criminal Court, they discussed this issue of sexual violence with the judges over there to learn more about the experience of international community to bring that experience to Ukraine. This memo accumulates all this experience. It'll be useful for the representatives of the law enforcement officers, for the judges in the pre-trial investigation and at the examination of the cases at courts, of the cases that relate to war and hostilities. Today, the Ukrainian public and international community is very much interested in investigating sexual violence related to war. As the branch of judges, we understand that investigating and bringing to justice perpetrators will be the burden of the national system. That's why the courts will have to follow highest possible standards for the whole world to understand that the Ukrainian decisions are lawful, legal, and fair. This booklet will not replace codes or Ukrainian legislation, but this will be a booklet that will be used by the judges to pass judgments on these complex cases, for them to work in an efficient manner, in timely manner, and in a fairness for the perpetrators. Many parties have participated, including the Ombudsman Office. I would like to ask Mr. Osipov to highlight the role of the Commissioner for Human Rights, and in general, what's the role of your office in combating war-related sexual assaults and offenses. To begin with, I would like to say that the office has been actively participating and is welcoming this memo. Again, welcome everybody. I would like to thank the NGO UA experts for their interested and active position on combating and investigating crimes of this nature in Ukraine. I think there are a couple of things to be talked about. Decade of war since 2014, and then since the full-scale war, the scale of crimes has grown. The crime that we talk about today is only part of the bigger picture. Violence in general, as we know, doesn't know the categories of sex and age, because what Russian soldiers have committed here is appalling and egregious. I would like to echo what I have heard, is that more than 270 cases of sexual assault has been registered. Apart from all the efforts, this crime is enveloped in an atmosphere when victims are not willing to talk openly about their experiences. It is worth mentioning that after the deoccupation of the liberated territories, what we see is everywhere where there were Russian boots, we register such crimes. Russian Federation is weaponizing sexual assault as an instrument of dehumanizing and humiliating the Ukrainian people. I would say that this memo is a marker of the work and consolidation of effort of the NGO and the government in order to bring to justice those who have committed crimes, either today or later. A couple of points to be singled out are these. It's important to raise the trust of the victims to the law enforcement in parallel to developing the methodologies of how to work with the sexual victims. This is the area where we should be moving very fast in a consolidation of all efforts and all stakeholders. As far as we are concerned, my office is focused on a person. We want to promote the work on recording the war crimes, collecting evidence for them to be used by the international bodies, and bringing the highest ranks of the Russian rulers to justice. My office is an intermediary between the bodies of law enforcement and those who make records of these war crimes. We are now creating a basis of evidence for the future international court. Those who are to be brought to justice shall be brought to justice. We have heard today that this is a new kind of crime, but this is something that is widespread throughout Ukraine. It is important to teach judges how to work with the victims of such a type of crime. Tamara, I would like to turn to you how judges will use this booklet in their education and training. Thank you for the invitation. This is the second time that I participate in such a discussion. With me are Tatiana Fuley from my School of Judges. She is a member of the Intergovernmental Group on Implementation of the UN Program for Women, Peace and Security, a person who will participate in the discussion. The National School of Judges did not immediately participate in this booklet, but as we have heard from the head of the Cassation Court, they think it's worthwhile doing. We have also regional first instance judges here, people who receive cases and are engaged in examination. These are the people that will pass on the decisions and will refer them to the international courts. The experts say that, unfortunately, our judges have to form this base for the International Criminal Court that will bring in suits against perpetrators of this war aggression and those who have perpetrated war crimes. To be sure, the arms conflict is raging for 10 years now, and according to the curriculum of the National Court of Justice, all these topics, including international offenses with the sexual assault, are part and parcel of the curriculum. In 2022, we can say that the direction of the education has changed. If you look at our curricula, we have an official site of the National School of Judges. The major effort is targeted towards training judges, focusing on the war crimes with the support of the La Strada NGO, and Tatiana is the author of the training program on the cases on sexual assault that is related to arms conflict. Let me read out a curriculum that has been developed in 2022. We have conducted trainers for trainers, meaning that we have covered all the regions of Ukraine, and they're part of the training process. Due to the projects from the Council of Europe, Judges for All by the USA, Justice, program. In 2023, we conducted about 100 events, including webinars, training, roundtable discussions devoted to the topic of war crimes, and a training on sexual assault include different aspects of international regulation, qualification of the sexual crimes according to the Ukrainian legislation, and the specifics of developing court decisions. This topic has generated a lot of discussion. It must be worked upon to come up with a single approach. We have also devoted a number of the curriculum to the interrogation procedure according to the Ukrainian criminal code and the psychological work with the victims and the way to make up for their traumas. Again, as for the development and teaching of this training, it includes a lot of psychologists who work with us at the National School of Justice. This is just a nutshell of what I could say. If judges are willing to, they will participate in the discussion. Of course, Tatiana and Yulia, as our teachers and the developers of this curriculum. Thank you. We have talked a lot about the importance of this memo. Let us go right to the memo itself. Angela, could you tell us about its structure, the chapters, and what's the importance of it? First of all, I would like to thank the organizers for the invitation. I welcome the judges present here in the audience. As you have mentioned, you are right that Ukrainian judges will be those who will form the basis for this particular procedure. The memo does not aim at teaching Ukrainian judges how to write a court decision. We know how to do that better than anyone in the world. The experience is there. The aim is not to say how to do it. My vision of this memo was to turn attention to the problems that are there in the national legislation and to single out those collisions of the Ukrainian legislation and international experience. My main idea was to make sure that the Ukrainian legislator does not reflect on the challenges, but rather would be well taught in this sphere what are the consequences of applying of such a legislation. We see reflection of the Ukrainian judging community in the how we judge on the collaboration cases. It means that the quality of our legislation leaves much to be desired. That's the first point. The second point, my wish is that national legislation, the Ukrainian legislation, had a higher quality responding to the level of the highest international criteria. I have looked very closely at the table book for the Ukrainian judges developed by the School of Judges. It analyzes and puts forward materials relating to the court decisions of the international bodies, the international norms and procedures, conventional points, everything is there. It has a encyclopedic nature. But again, this is the reflection of what is still there. I would like to go back where I proceeded from the video that we had seen. There was a word impunity of evil. Sexual assault, let me tell you, that is related to conflict. And we see this in the decisions of the international bodies, including Rwanda. It mentioned that sexual crime is part of the genocidal actions. Going back to the issue of genocide, Article 442 of the Criminal Code of Ukraine does not necessarily correspond to the definition of genocide in the Rome statutes. That's the first point. What I fail to see is the legal initiatives on this issue, although we have been constantly talking about genocide. I am leaving behind the issue of impunity of evil. Every one of us, we understand that better than anyone else. Genocide didn't start with the Russian aggression in 2014 or full-scale invasion of 22. We know the years of 1937, 1938. That's the matter of genocide. The thing is, this evil enjoys impunity, and impunity of evil will cause another evil. What is most dangerous here is that impunity of evil makes the perpetrators of such an evil act. They will understand that they can go on. This is a complex issue. To recognize the genocide of the Ukrainian people, the events prior to the Second World War, because formally it is difficult. At that point in time, the criminal legislation did not provide for the criminalization of genocide. It wasn't there. And the court of the Kyiv appellate court, even today, to try to pass a court decision of the chamber of judges, bringing in genocidal accusation of Stalin Beria and that ilk. We have not been successful even within Ukraine. It was just an attempt. How effective and formally legal it was is another issue. To reiterate, the issue of genocide. I personally understand that every form of the manifestation of aggression, including sexual crime, are liable to be recognized as a genocidal action towards the Ukrainian people. The propaganda from Russia and even actions in the territory of Ukraine testifies to that fact. Going back to the sexual assault related to the conflict, there is a point of collision here. Today's activity of the General Prosecutor's Office qualifies such actions as Article 33 as flying in the face of the norms of conducting war. I will tell you this. The Article 33.8, in the first part of it, second part deals with another issue. The sanctions there are less than the sanctions for rape provided for in the criminal code. And here we say that CRSV, irrespective of age or sex, according to the rules of qualification, the theoretical issues and scientific issues, qualification should be that it is a more grave assault. You see, the rape of the juvenile is a grave crime with a statute of limitation of 15 years, according to the Ukrainian legislation. At the same time, according to the Article 438, the statute of limitation is employed. I'm only drawing your attention to this, because when we talk about the qualification, about the fact that judges should be mindful of that, let me give you an example. In Balkan War, the victims of the sexual crimes, even as of today, how many years have passed, are courageous enough to report those cases, and it should be assessed and evaluated after that many years. When we are guided by the Ukrainian legislation solely, it'll be a complex issue to defend a victim. Can we go back to the memo? How it'll be a game changer. It'll draw attention to the complex issues. It will be able to help the law enforcement and the judges, whatever the qualification might be applied, but they will have to turn a close eye to such points. And I think it has a practical issue. I see people from National Police here. He's constantly participating in our discussions. Very unfortunately, I even don't know what the fine wording is. National Police is tasked to investigate crimes going 438, and Article of 216 has not been changed. When we read Article 216, it says different things. I understand that the security service of Ukraine is dealing with more serious cases, but it has to do with the health and dignity of the Ukrainian people. And their health and dignity and life is the highest value of the Ukrainian system. I think police must be engaged in investigating such actions. But you see, the jurisdiction is elsewhere, I think, and it should be rectified. I'm only drawing your attention to this fact. Judges should be mindful of that. At the national system, within it, we sometimes ignore the rules of jurisdiction. Why I think it is important? The verdicts of the Ukrainian courts, according to Article 438, do not preclude a fact that the leadership of other country should be brought to justice at the international level after the conflict is over or after this aggression is over. And if it is not a barrier to bringing these people to judges, then our court verdicts will be constituting a basis for international investigation. But international bodies, including the investigation by the people who are empowered by the state, is granted more attention and more importance as compared to what we have here in Ukraine. That is why the main point of this memo is not to teach how to investigate cases. We have very highly qualified judges and prosecutors, not to teach how to write court decisions. We can teach other countries. The point is to draw attention to the problem issues. Those who are dealing with this, and especially the legislation that must be changed to come up with a decision on this challenge. This is what we have, and this is what our vision is. Now that Ukraine will ratify their own statutes, And this issue hangs in the balance. This is one of the points that would bring us closer to the European legislation. I will be ready to answer your question. Before I ask the next question, I would like our next panelist to come online. We have mentioned the issue of adaptation of Ukrainian legislation towards that of Europe. Evgenia, could you tell us, from the vantage point of the Vice Prime Minister for the European integration, what's the role of this booklet on CRSV? We can't hear you, unfortunately. You are not unmuted. We haven't heard from you now. We don't see you.
З вашого боку, швидше за все, проблемка.
Think you're running technical issues there.
Так, я не могла включити себе. Це треба.
Thank you for the support. Sorry for these technical hiccups. Can you hear me? Can you see me? Now, answering your question, I would like to welcome everybody. It's such a pleasure to discuss this very important document. This is the result of the cooperation interface of academia, of judges and experts. This is a document, is part of our work, a comprehensive work on response and prevention of sexual violence in the environment of war. All our developments, something that we are discussing now, is a unique experience. Our international partners are trying to teach us the experience of history. I think a few years from now, we will be teaching other judges how to react to the cases involving conflict-related sexual violence. This document was not called upon to teach judges how to write verdict, of course, but rather to come in handy with an instrument for a more professional and, shall I say, more comprehensive and deep legal norm of how to describe these norms in different documents. Since the beginning of the full-scale war and going back to 2014 and full-scale invasion of 2022, Ukraine and Ukrainian public are suffering from these crimes. And sexual violence is part of the elements that is not used elsewhere. It's a weaponization and a special instrument of the Russian aggression against Ukraine. Quite recently, a special representative of the United Nations singled out in her report a situation in Ukraine that this is a pattern of war. It's a targeted strategy of the Russian military in their relation to the Ukrainian civilian population and beyond. That's why the judges will appreciate, the prosecutors will appreciate, and the investigators will like this because they know the norms of the international law. We want them to come to best possible results and to come up with new norms and provisions. When we develop new provisions, new systems, we can effectively react to these crimes. The priority of these issues for Ukraine is not a matter of protecting the rights of the victims, but it is also important in terms of responsibility to make sure that any criminal everywhere in the world will be prosecuted and will be brought to justice. The gender-related crimes will not be muted, they will not be stigmatized, because when victims know that there is a perfect legislation and the system of investigation, people will share their sufferings. This is an instrument for fighting for justice and for the rights of the victims, for their rights to be reinstituted and the rule of law to reign and to triumph and to be respected in Ukraine as well as in the world. I would like to thank all the authors, my colleagues, who will continue this important work on improving the judicial branch of power to make sure that legislatively and judicially the situation is improved. Thank you. At this point, I think it makes sense to feed questions from the floor, from the journalists, from the viewers. If you have comments or questions, you are most welcome to participate. Grab that microphone and you will participate in our discussion. Tatiana Pasova from Ukrinform. My question is this. You have mentioned the number of 274 cases related to the conflict-related sexual violence. It is obvious that this is not a full list. What is the reason that the number of victims, those who turn to the law enforcement, why people are not willing to share their experience? I personally will say this. We use the cases that we receive from the General Prosecutor's Office. However, as far as the verification of our NGO, we have referred a number of cases after which they were entered into the register by the General Prosecutor's Office. And we provided the interviews of the victims, of the investigators and doctors who have witnessed on the facts that they have seen as witnesses. And I'm sure that the verified numbers should be analyzed, solely verified. Don't remember the facts that are muted, and they will see the light of the day at some point in time, because this is the right of a victim not to share information. People are legitimately right in being not willing to share, but I'm sure that the number of cases will grow constantly. But the numbers that we have available, of course, it's more than 274 cases, let alone the facts that there are children that have been born as the result of the war-related sexual violence. There is such a term, unseen generation, meaning children born as the result of the conflict-related sexual violence. Now we are facing a situation when parents of these children and those people think about social protection of these children, including the guardians, their parents. The national services, together with international NGOs, announced that they have a budget for 400 persons, and there will be payments delivered to the victims, although I don't know how personal data will be protected during these payments, who will be first in the line to receive such finances, but that's another issue. To conclude, I will say that 274, according to our data, is much lower than the number of cases in reality is. Let me tell you that not only conflict-related sexual violence, but any sexual violence during peacetime is a category of the latent criminal actions. In the first place, it's there not because there is a lack of methodology or the lack of willingness to investigate. It has to do with the unwillingness of victims to share the information on different bases. Sometimes they are ashamed, sometimes they blame themselves. Sometimes the public awareness isn't there, and the culture in general is not inducive to sharing such information. Society in general is not ready to divulge such negative information. That's why the number is that few. I mentioned the Balkans, and there are verdicts by the courts and the assessment of the sexual violence. The victims of sexual assault there, even today, can appeal to court. Some time has to pass, not only within the reception of the victims of the sexual violence, but within the society that will be ready not to blame others and will be ready to help and lend a helping hand in terms of finances and in psychological support and help by developing adaptive mechanisms for the victims. The victims should not be blamed. They should not feel the complexes of inferiority. The fact that we have psychological programs is a small part, a first step towards the massive challenge that we are facing. This is why we know so little about the cases that have been recorded. But of course, there are many more of them. I will agree with Sergiy that in the future we will see more and more of them. Once the victims of the sexual violence know that government is taking care of them, once they know they are supported, once they know that they are not restricted in their rights, that they are not receiving handouts, but rather they are fully fledged members of the public, only then will we be able to see a growing number of these people coming out. Thank you. Do we have questions? Shevchuk asks from the body of the data protection. I think it's a very good thing that we are discussing today. It'll draw our attention to the conflict-related sexual violence crimes. It's one thing. The second thing is that while data is collected and evidence is collected in such investigation, confidentiality of the personal data is important as far as conflict-related sexual violence is concerned. As for the Ukrainian legislation, the data of such category are deemed to be especially sensitive. It has to do with the dignity and honor of these people. And when data is collected, when the reviews are conducted, when the evidence is gathered, when the data is transferred between different bodies in Ukraine as well as to other countries, we should be mindful of the maximum possible protection of personal data to make sure that the personal data is preserved at the highest possible level. This will also mean that people will come out and share their experience and will testify. This will also be inducive to a new investigations of the cases that are conflict-related sexual violence cases. Welcome, everybody. My name is Nizhynskyi. I am a national coordinator, and I have been actively engaged in developing of this memo. As for the first and second questions, let me tell you how the memo can be used. Of course, it is targeting the law enforcement community and judges, but we also have written in the preface that it can be used by the human rights activists, lawyers that participate in the court examination representing the victims. We have conducted a number of events prior to the publication. One of the forums saw representatives of the lawyers, human rights lawyers, people who represent victims of the conflict-related sexual crimes. And these people told us about the specifics of such cases. The lawyer must insist that the sitting of the court must be closed. The lawyers make sure that the personal data is not leaked out. They can use this memorandum to guide the investigation, to actively participate in the examination, to insist on a proper qualification so that the motivational part should refer to the international experience, the cases of the International Criminal Court. That is to say that lawyers are actively engaged in the trials, and they will use this memo to defend their clients. Thank you. Would anyone else like to participate in the discussion? Tatiana Foley. My name has been mentioned today. I come from the law school. I would like to draw your attention to the following points. One, if the goal was to draw attention to the CRSV, then they have, of course, fulfilled their goal. And the discussion that we are seeing over the last years, this topic is not muted anymore. It is not smothered or concealed. There are a lot of events at the highest possible level. We remember the international conference where the First Lady participated, and all the stakeholders were also engaged, including NGOs and the victims. That is to say, compare that where the situation was during the Balkan Wars. Of course, we refer to that experience as the international response to such crimes. Now, the situation is much more open for a public discussion, and of course, it will stimulate the victims to come out. It's a constant matter of our discussion that the number of cases does not reflect reality. In general, the issue is this. There are a lot of aspects. Judicial is one of them. That is to say, we have mentioned that rehabilitation, psychological help, and compensations, it's not a matter of judicial nature. The presentation started off with a message that evil must not be immune and should not enjoy impunity. When we talk about the punishment of the perpetrators, it is a point to remember that a court suit is only the peak of the iceberg, is the tip of the iceberg. And of course, it goes without saying that international and national instruments is something we should know about. But I don't see a point in discussing the legislation. This is the legislation we have. Of course, we would like the legislation to be not reactive but proactive. But the legal regulation that we have, not only in criminal jurisdiction, is something that we have. Sometimes, of course, legislation lags behind the challenges, but the criminal justice is this. The court is the body that solves a dispute in civil sense of the word, and it appoints the penalty and the punishment according to the criminal code that is being investigated. The standard of proof is beyond reasonable doubt, but we should also be mindful of the qualification. People and judges here will tell you that qualification is very important because penalty will be defined by the qualification. This is what the court works with. These are the materials that the court will receive. In this aspect, the role of lawyers defending the victims and defending the persons that are respondents is very important. Only because if a prosecutor has proof and prove them to be beyond reasonable doubt, then it'll define the quality of the court decision. It's very important that this memo includes international instruments, international court decisions, and the European Court of Justice of Human Rights. Of course, they have been sorted out in a very strange manner. But I would like to draw your attention to a specific case when we talk about qualification and proof. It's a case MS against Bulgaria. It's already in history. It goes back to 2003, but the precedent is very important. It has been translated into Ukrainian by Yuri Zaitsev and his practice of European law. The full text is available in the Ukrainian tongue. Why is it an interesting case? It's not because it analyzes the available international practice, available then, of course, on the international standards of investigation and proof. It also lists a decision on the international tribunals as part of the international practice to be compared with very important concepts. And of course, it had to do with the conflict-related sexual violence, including a minor. This is very important and will be useful for both parties of the court's decisions. Do we have comments or questions? In case you have, there is a time for you to voice them. Otherwise, So Sergiy, to conclude, can I turn to you? Who will be the recipients of this memo? In a couple of words, how would you draw conclusion under today's discussion? Colleagues, it is a principal matter for us to talk about this memo through the media. In the first place because it has seen a lot of discussion, and it is high time that we drew the line in the sand here. Irina Nizhynskyi, unfortunately, hasn't made it here. She worked in Bosnia-Herzegovina on the part of the United Nations. And before this presentation, I talked to her about the importance of this memo, and the previous speaker also mentioned that, how important the Balkan expertise can be until and unless Ukraine continues to exchange the prisoners of war who are suspects of rapes, and it has been proved, we will be in a gridlock, and it'll disrupt cases. Keeping the evidence is a key point here, and it was a key point in the Balkan region when conflict-related sexual violence is concerned. This is what we should not leave behind in terms of law enforcement. This is the first point. Second important point is to draw attention to this kind of crime, not only through some events, but rather sharing the information on how you can be protected, the list of the documents related, those people, and I thank them, who have verified international jurisdiction. It's not a list of references. They have selected the European directives and specific courts that empowered us not only before the trial, during the trial, or at the trial to refer to, but to come to the bottom of the logic of some decisions passed, including Rwanda, Bosnia, and Kosovo. We have been actively engaged in work with the Kosovo Rehabilitation Center, and they talk about 20,000 victims. They also have their expertise and running risks as far as preservation of evidence is concerned. Is to conclude, on the 19th of June, we will mark, I would say, the community will focus on the International Day to combat conflict-related sexual crimes. We will run a number of events, media events included. You see this flower, which in Russian, in English, is rapeseed, and it is not a coincidence. We have selected this particular flower to show the solidarity of the international community. We want, with this rapeseed, to serve as the reminder that Ukraine is leading the way in working the methodology on fighting the conflict-related sexual crimes. Don't be indifferent. Thank you. We have been talking about the memorandum for the law enforcement and judgment for effectively investigate conflict-related sexual assaults. Ukrainian Media Center will continue our work tomorrow. Keep track of our work. Glory to Ukraine.